KIIT School of Law, KIT University, Bhubaneswar. And I've done my graduation from KIIT University in law, LLB, and I've done my master's from IIT Kharagpur, the Rajiv Gandhi School of Intellectual Property Rights, and I'm currently pursuing my PhD at Utkal University. So I really now let me take an opportunity to thank Sanskriti. Thank you, Sanskriti, for inviting me to the session. And I hope that all of you get involved in the session and do not consider this as just another online class. Okay. So let's start with it. I'll just share my screen. Okay, all of you, is the screen visible to you? Yes, okay. Okay. So, as we start, the topic of intricacies of data protection and privacy laws in India. Can someone tell me what the Constitution of India talks about privacy? I'm sure all of you are law students. Is there anyone who is a non-law student? No one? All of you are law students. Okay. So, so when we're talking about Constitution of India, so it starts with where right to privacy was not earlier. It was not recognized as one of the integral part of fundamental rights, but later we considered that right to privacy after the Puttaswamy judgment. I'm sure all of you have come across it. We come to the point where after the Puttaswamy judgment, we have accepted right to privacy as one of those fundamental rights. But for the longest period of time, we did not have any right to privacy. Now, how I'm sure a lot of you use smartwatches, right? I request any at least to have some conversation with me. All of you use smartwatches? Any one of you
Yes,
use a
ma'am.
smartwatch? Right. Okay. So when we are using a smartwatch, why do you use a smartwatch? What do you think of using a smartwatch? Why do you consider it is important to use a smartwatch? Tell. No one. You don't consider it important to use a smartwatch. Then why did you buy it? No idea? Okay. No problem. So whenever you're looking at a smartwatch, you consider that buying that smartwatch was important to you because probably it came in trend. Okay. You are more influenced by the peers that they are using a smartwatch. So you buy the smartwatch. But the moment you buy the smartwatch, you're also entering into or accepting a lot of things which you did not want at one point of time. Okay. Which you did not think was important at one point of time now seems important to you, as simple as knowing your heartbeat, knowing the know how much workout have you done, and or whether how well did you sleep throughout the night, whatever. Okay, so when you are having whenever you are using a smartwatch, the moment you log in into a smartwatch, the smartwatch asks you that please give me the access to your contacts, to your gallery, to any albums. Okay, so any information which the smartwatch does not require, it does not require to run, because your smartwatch is meant to give you the time, it is meant to give you the heart rate, the heartbeat rate, probably the number of steps you have walked in the day, just to calculate how fit you are. But however, you still know that it is not required to run the smartwatch. The intricacy of the smartwatch is not getting access to your contacts or to your gallery, unless again you have bought a smartwatch which can have a conversation, the Bluetooth one. Okay. So each of them have different requirements. However, even if you are having a smartwatch, we need where you need to talk, okay, where you are having that where it's a Bluetooth connected smartwatch where you can have voice calls, it still does not require the access to your gallery. However, you end up giving the access to your gallery because you just don't, you subconsciously think that okay, it might be required, and you click on allow button, which is unnecessary at that point of time. This is where you, as a user, data user, or as we say, that you are on the end user, you're the end user of the product. What you do is subconsciously you have given rights to hamper your privacy. You do not you did not think twice before giving that acceptance. You allowed them to to get access to your gallery, to see into your images, and later you cannot, and later if you're not able to undo it, in that case is where you come to where we have our data protection laws. Okay. Everyone is able to understand? Am I going too speed? Am I speaking a lot? In a, should I slow down my pace?
No, ma'am, it's okay.
It's okay. Okay. So, this, when we are talking about privacy, and we are talking about data protection laws now. Okay. So we have our constitution, we have our data protection act. Remember, when I'm writing data protection act, here it is about the digital data protection act. Okay, digital personal data protection act. We have our information technology laws and our data protection principles. The data protection principles are coming from the general data protection principles, that is your GDPR. Okay, general data protection rules and regulations, that is GDPR of EU. And from EU, we have certain kinds of principles which have been exactly same incorporated in our data protection act. Now, when we start with constitution, I told you already that it starts with Puttaswamy judgment, where it was declared that right to privacy is important. Right to privacy is very important, and it should be a fundamental right. It cannot be taken away from a person at any cost. When we're talking about information technology laws, again, information technology laws gives you a lot about where, how our, so information technology laws has one more thing. Okay, I'll just no, very important thing which has been clarified. This, there are three types of data in our information technology laws. One is the personal data, second is sensitive personal data, and the third one is critical sensitive personal data. When when we're talking about data, or we are talking about information, the moment we're talking about data, it is not processed at one point of time. After processing, we call it as an information. Okay. If randomly I ask you names, or I see into Ronak, Avnish, Priyanka, Arpita, I don't know where you belong to. Then I start asking you where you belong to. Then I start taking your phone numbers. If I randomly write Ronak and I take the phone number of Arpita, it will not make sense. But the moment I process it, I divide it into people from east, west, north, south, probably. Or if I divide it into colleges, KIT Law School, Symbiosis Law School, Christ, Opijindal, whatever. If I divide it into national law universities, private law universities, somewhere I try to bring a difference. That is where we are converting a raw data to an information, which is much more informative, much more clear. Okay. When I'm talking about personal data, it is more about what's your name, or basic, it's not that personal. It is not in a stage which will create an impact on a person. When I'm talking about sensitive personal data, now remember one thing: sensitive personal data is defined very differently in our IT Act, very differently in our Digital Data Protection Act, and also in your GDPR. So sensitive personal data tells you what? about going entering into more details, your sexual preference, your birth date, your gender, all of it. Okay, it is more about how do you it is a little more intimate to you, it's more important for your personality, and you know that losing leaking that data can hamper you in some point. Critical sensitive personal data can involve military based personal data. Critical sensitive personal information may include your Aadhaar card details. It may also include the health records that hospitals have, and mostly it is health records. I'll give you a very simple example so that you can relate. How many of you have watched Breathe, Madhavan's Breathe, the series? Has any one of you watched the series Breathe? No one? None? Do you remember a series like that existed? Breathe? No. Okay. No. Okay. So there is a series. Okay. Breathe. You must go back and watch it. But it's a good series. Okay. Uh, so in the series, at one point, so there are organ donors. Okay. There are organ donors. There are a lot of organ donors in the society. So this hospital has leaked the information about, the list of organ donors. Okay, and Madhavan's son is one of them who had to receive. Yeah, Madhavan's son is one of them who had to receive the organ to survive. So uh, when he wanted to, the moment he got the list of the people who were the organ donors, Madhavan right away went on murdering people, just so that, murdering those organ donors, just so that his son can get one of those, the organs which his son needed to survive. So if his son was in the list number 6, so he murdered 5 people at least, just so that his son gets the organ as soon as possible. Now, why did it happen? It happened because a privacy law was hampered. A data which is related to a patient, a data which is related to a human, where the person is very clearly, it is important to know that this person clearly, that data is very clearly intimate to the person. You cannot just leak the data of a patient, you cannot leak the health data of anyone without taking the permission, without taking in the consent of the person, and it was leaked. So what happens is the repercussions are worse. Okay, so we do not know that what kind of information which will create what effect at the society at large. So privacy that way, if you see, is, our information technology laws gives us a lot of it. So when we are talking about data protection, it is more about how are we safeguarding those data through, against those unauthorized access, use, disclosure, or destruction. Now all of us know what hue and cry Aadhaar card, the leakage of Aadhaar card had created, that, what if it gets leaked, or for that matter, when the whole the no there was a mandate by the government. Every time there was a mandate by the government that this is where you should link your Aadhaar card, even in your bank accounts, even in your phone numbers, for a matter, for everything possible, they started linking your Aadhaar card. Where this is where privacy was hampered the most, because all the details of the eye retina scan, all of it was considered to be a part of the sensitive, critical, sensitive personal information, and it should not be disclosed to any random person possible. So this was an unauthorized, you cannot mandate something against the will of the people. So unauthorized access, use, disclosure, and destruction means hampering of the privacy. I'll give you a very simple example. A lot of us nowadays, we are very much into, we are into social media, and we post pictures, we talk to people, we do not know what kind of information we are sharing, we do not know how much control we have over the system. And in that matter, there are a lot of other, there are a lot of yeah, there are a lot of situations where people tend to talk to people, as in talk to artificial intelligence as their uh, therapist. Okay, there are a lot of things that you browse, you try to talk online, which the other person does not exist, all of it, and you do not know what you are sharing, but somewhere it is stored in the remote server of Facebook, Instagram, Twitter. It is stored in in some kind of server, which later may be used against you, or may be accessed without you, without the consent of yours. So what kind of information, what happened with Riya Chakrabarti, no? I believe her name is Riya Chakrabarti. What the Sushant Singh Rajput case, what happened was, her private messages where clearly it is written end to end description, encryption is there clearly, still her private messages were being accessed by whom? By the social media intermediaries. And they were given to, it was given to the police, where they had discussed about a substance which is not allowed in India. So when we are talking about such instances, we should know that what we are sharing, should that disclosure that we are giving online, whether how much disclosure should you give, and whether it can be used against you or not. So data protection is a two-way process. You cannot put it everything on the intermediary, that it is the responsibility of the intermediary to take care of the data. It has to be two ways. As a data, they're just the data controller, but you are the data users. You are the end user of the software. So you should be more careful about what you are sharing online. Okay, and when we are talking about where you know that WhatsApp writes end to end encryption, you believe it is a private conversation, but sometimes it is not a private conversation, because at the end, it is the WhatsApp server which stores all your pictures, all your messages, so that later on, in case of any complexities that arise, they are able to do it, or they're able to give evidence to the court. Now remember this example, and I will tell you where it has led to as a law in India. Okay, remember this example for now. Then, so when we are talking about data privacy, we have to ensure that our personal information is controlled by us, and it is only controlled by us, no one else. Again, I'll give you a simple example. Have you all of has any one of you watched Connected? Connected as a series. Connected. No one?
No, ma'am. No.
No one? Okay, then you must watch. Okay, I'll give you a list of series you must watch after once you and once the session ends, keep it in your watch list. So connected there, one of the examples. So we use dating apps, right? Uh, and you use dating apps, not Facebook, Instagram, or messaging apps, but dating apps are like Bumble or Tinder, and you use these apps to get to know other people. Now the concept of these dating apps are where you are using those applications to get into a relationship, or you find out like-minded people, or you want to find someone, you want to date someone who your bandwidth probably vibe match karna chahiye. You have that ideology. How many of you know that you do not control it? You do not control whom you are choosing. It is the artificial intelligence which is controlling whom you are choosing. Okay, because the moment you create a profile, I create a profile today, probably they will give me that, they have a rating of beauty. They have a rating of beauty. And they will rate you in their standard of beauty, as whether you're dusky, whether you're black, whether you're white, whether you're fair, whether you're very fair, you yellow fair, pink fair, they have a list of filters where they're going to put you in. Because when you create a profile, you look for people of that similar category. Okay. And the artificial intelligence will give you only those options with whom they think the beauty, the standard of beauty matches it. The whole concept of beauty lies in the eyes of beholder is false when it comes to dating applications, because they will tell you that okay, this is the standard, you are a 50 out of 100, you are a 40 out of 100 in beauty, so we will give you men who are exactly 40 or within 45, and it goes the same way. Okay. So these dating apps do control your choice of choosing the people. If they can control a choice of choosing of people of till that point, then imagine what all they can control in your life. So technically they are not letting you choose a life partner of your choice, because they believe you are not beautiful or you are very beautiful, depending on their categorization. This is also where our consent or our purpose, or our control over the data is lost. We do not know what they are using for, how they are using for, we do not know about it. So this is one point where again, data, ensuring that that data is secure, is became a very major importance in today's date. Okay. So data protection refers to safeguarding those individual personal information, and they also ensure that you have to build trust between the individuals. So I've already told you the types of data. Then we come to the principles of privacy. These, if you remember these principles of privacy, you know every part of your digital data protection bill, Act 2023. Okay, if you know these principles. So the principles, so these are the purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, accountability, and fairness and transparency. So tomorrow, if you go to buy a car, okay, let's say you're going to buy a car. The moment you buy a car, they take a record of everything, your name, phone number, all of it. The moment they take it, you believe you bought the car, you're the owner of the car. But this is where the problem starts. You start getting calls from a lot of insurance company. You start getting calls from people, कि कहाँ कार बंद हो जाएगा तो उसको उठाएं कहाँ से. All of it, all kind of information. Or for that matter, you get calls from banks, you get calls from washers, so many calls. How? Because those data are being leaked or shared without your permission to a third party, without taking your permission. But if I am asking you the data, if today during this conversation I tell that please share, Ronak, please share with me your number, because I want to share your number with XYZ. So this is a transparency that I'm talking about, the clarity that I'm talking about. So the data collection should be transparent, should be lawful. You cannot collect the data in an unlawful manner, also for a unlawful thing, like in contracts. I'm sure you, all of you might have read your contracts already if you are into law. So contract act says lawful use, lawful consideration. Okay. So it should be lawful, it should be fair, and it should be transparent. Purpose limitation says that if you have collected it for a purpose, you can only use it for that purpose only. You cannot share it without my permission. We do not, what we do is we don't care about it. Okay. We don't care about it. So we don't ask or we do not question back that why did I get a call from an insurance company after buying my car? And I've taken already an insurance. The moment I buy a car, I've taken an insurance for my car, but I'm still getting 10 other companies to call me. That means the purpose is violated already and my consent was not taken. Okay. And it is important that you take accurate information. For example, today, the accuracy of information depends on how much updates you give. If you open Facebook tomorrow, and suppose today I'm single, tomorrow I'm married, day after tomorrow I'm divorced, does not matter. If I don't update it in Facebook, then Facebook would not know about it. So accuracy of it. Storage limitation again tells you that Facebook can only store your data for this many years, not beyond that. So earlier it was 40, 50, 60 years they used to store the data. But now they have all the, applications have narrowed down their storage limitation principle that you can only store it for a certain amount of years, like 10 years, 12 years, 8 years. It's a very limited number of years that you can store the data for. And for maintaining the integrity and confidentiality of the information, you will always have to appoint a data protection officer who will take care of the confidentiality. You cannot share that information. And in case there is any leakage, then immediately you have to inform it to the CERT in team. So we have in Indian team a team of people who will ensure that the accountability is taken care of. In case there is a leakage, in that case, as soon as possible, someone should get hold of the information and try not to continue the breach. Try to ensure, you ensure that it is protected. It is more of damage control. Damage control is important. So you do that. You stay accountable for it. Okay, and the intermediary is accountable for any kind of data leakage. So then these are the data protection laws in India. Okay,
Excuse me, ma'am.
we start. Yes, sure. Tell.
इंटरमीडिएरीज मतलब कौन कौन से उसमें आएंगे?
Acha, okay. So an intermediary is what? An intermediary is anyone who is controlling your data. Okay. It's a third party. A third party is called as intermediary, like Facebook, Instagram, Twitter, Google for that matter. Google, anything you Google, no? You go. So what you do? For that matter, eBay, Amazon, Flipkart, these are what? These are all platforms where two people meet. Okay.
Yes,
So there
ma'am.
will be
Got it.
end use. Got it? Okay. So they are the mediary. They are the one who are giving you the platform to exchange the information. Okay. So these intermediaries are very important when it comes to privacy, because they are the one who are mostly dealing with, because their privacy policies is what makes difference in your life. The intermediaries becomes liable whenever you share an information and they continue resharing it without your consent, or they do not, they're trying to use that information without your consent. uh, Very simply, if you start searching of traveling somewhere, you will see Instagram starts giving you a lot of, you know make my trip and yatra.com, a lot of information in Instagram. Or you start talking about something and you see suddenly you are having advertisements in Facebook, just because you have googled it. That means what? Google is keeping a track on your digital footprint, and that digital footprint is shared with other applications which you did not allow. You did not tell that, you can reshare it, or you can continue sharing it with the other parties. However, Google has done it, but subconsciously you might have done it if you allow the cookies. The moment they pop up, allow cookies, selectively allow cookie, all of it. If subconsciously you have clicked on allow cookies, then all of it will be, or you try to give them the permission. This is how smartly they enter into getting the permission of using your data and giving you more information which you did not require at that point of time. Even in incognito mode, remember, your incognito mode is not exactly incognito. You can try any application in incognito mode, you will get all the advertisement in your Facebook or Instagram within seconds. So it is a farce that you think that incognito mode is protecting your privacy and you can search things up and no one would know about it. Okay. It runs with location. Okay. So these are all intermediaries. Okay. Intermediary liability is there in your section 79 of IT Act. And intermediary liability says that if the intermediate, it is the it is the accountability of the intermediary to prove that they have not done, they have not initiated or they have not shared any information without the consent. The burden of proof lies on the intermediary. Clear? Understood? I'm not sure who asked me the question. I think Abhishek. Okay, I'll move forward. Then, so data protection laws, we know it started with, like, I started with, Puttaswamy judgment. Section 43A and 72A tells that if you are, failing to protect the data, then there is a breach of the lawful contract. We have we have information technology rules, which says that there has to be specific standards that each of the company or the body corporate has to follow to ensure the protection of the sensitive personal data. The RTI says that there has to be a transparency in data protection. We have the Telecom Regulatory Authority of India. I don't know how many of you know about it, but if you write an email to the Telephone Regulatory Authority of India that I want my number deleted from random spam callers, then they have to do it. You will not get calls from random, spam calls if you if you request the Telecom Regulatory Authority of India, because they will protect your privacy. They're bound to protect your privacy. Okay. Then very recently we have come down to the Digital Personal Data Protection Act. Yes, Divyam, you wanted to say something?
Ma'am, I want to say that how can they filter that someone is calling who is a spammer or anything?
Yeah, so you will have to, honestly, you will have to give very specific names. Okay, that I do not
Okay.
want calls from these companies like Bajaj Finance ho gaya, yeah, LIC ho gaya. You write it down to them, and they will block those calls.
Okay, okay. And ma'am,
Okay.
one thing I want to also ask, you talked about
Ah,
Sushant Singh Rajput's case. In
yes.
that case, you told that the WhatsApp chat were provided to the authorities. So I
Hmm.
just want to require a confirmation from you. Was that WhatsApp giving that information to the authority?
Yes, it was WhatsApp which was giving information to the authority. I'll tell you why. Okay, I'll tell you
Okay,
how and
okay,
why.
okay.
So,
Because when accused in the custody, जनरली उनका
हाँ,
लैपटॉप और फोन ले लिया जाता है तो उसमें से भी निकाला जा सकता है दैट्स व्हाई आई एम
नहीं
दिस
नहीं नहीं नहीं, जनरली वो होता है, बट मैं ऑनेस्टली बोलती हूँ, कोई भी अपना ना, मैंने फॉर टुमारो, सो इट इज द रूल ऑफ लॉ. ओके, नाउ इट्स अ रूल दैट द इंटरमीडियरीज, अगेन हियर व्हाट्सएप इज द इंटरमीडियरी. ओके,
yes
so
ma'am,
the
yes ma'am.
intermediary cannot delete the information of a user till a certain point of time, like 2 years, 10 years, 30 years, jo bhi hai. Okay, intermediary cannot delete it. And especially when there is an accused, it is the duty of the intermediary to retrieve all information. Okay, and the
Okay.
intermediary has to bring that evidence to the court, give the evidence to the court. So this is where, so even if XYZ person has talked about a substance where, which is illegal in India, and later is accused of a suicide or murder or whatever it is the duty of an intermediary to retrieve that information and give it to the court, because
Yes ma'am.
this digital evidence is admissible in the court of law.
But in the privacy policy of these intermediaries, they provide a
Yes.
specific written explicitly. They write that we do not provide information to the authorities without your consent, or we cannot and we does not provide. Because when I search
No.
for WhatsApp, it is
Yes.
explicitly written in on a official website. WhatsApp cannot and does not produce the content of its users' message in response to the government requests.
Okay, it is written so, but in practice, it is very different. Okay, in practice, they have to
Okay.
do it because they cannot. Because what will happen if they are not doing it? It is obstruction to justice.
Yes, yes, yes.
So, right? So they have to. In practical, they have to do it. There's no question of not doing it. Why? Again, see, remember, in India is one such, there is no, after the Digital Data Protection Act. So I'll show you one more thing before I'll tell you the answer to it. 1 second. I'll bring my charger. Okay, give me 1 second. I'll just get my laptop charger.
Sure, ma'am.
interruption. Okay. So, when we about rights, okay, when we are here, if you see the Digital Data Personal Data Protection Act, it talks about applicability, consent, rights and duty of the data principle, obligations of the data fiduciary. Okay, why does it write rights? Why is it rights of the data principle and obligation of the data fiduciary? Is how I will answer this question. It is you are the data principle of it. Like I am the data principle because I have the data. I am the one who is giving the data. I am the one who is giving the information that I'm married, I'm single, I have this preference, I have that preference. I have a right to control my data. Tomorrow if I'm married, I write it to the matrimony website that see I am married now, please stop me giving any kind of the references. But it is also the obligation of the data fiduciary to remove my or delete my account from the matrimony profile when I ask them to. Here, in the obligations of the data fiduciary, one such obligation is in case of any conflict of law, in case of there is any issue. So why they have written that we don't provide it to the authorities? Because at one point, suddenly, if you remember, at one point, a lot of Twitter profiles were banned. Overnight Twitter profiles were banned without informing the other person, just because they thought that the person is posting something which the person should not post. How do you post this derogatory? But what is derogatory to you might not be derogatory to others, and also freedom of speech comes. So to curb that, that random authorities just tell you that, okay, these are the names, I want Twitter to ban it. Then any authority can interfere and tell that Twitter, please ban these people. So at any point of time, that is why it tells that we are not bound by the authorities. But if a case is filed in the court of law, in that case, they are bound to give. That is why our Data Protection Act does not have a right to be forgotten. If I don't know if you any one of you remembers the the right the whole discussion on right to be forgotten, because we in India we have right to delete, right to deletion of data. Okay, we can delete the data, but we do not have right to be forgotten. Right to be forgotten, if there is right to be forgotten, and if I write an email to any intermediary that I want to exercise my right to be forgotten, every part of the data has to be deleted. Every part, right? Start from my images, Google images, to what papers I've published, everything has to be deleted. So but once it is deleted, it cannot, once it is right to be forgotten, it cannot come back. You cannot exercise, the authorities will not be able to retrieve the information that they need to present person or put a digital part as an evidence. That is why in India we do not have right to be forgotten in our Digital Personal Data Protection Act. And very interestingly, our Digital Personal Data Protection Act is named Digital Personal Data Protection. It is not data protection, it is not personal data protection, but only personal data protection, because it only encompasses anything which is online. Any kind of information that is digitized or is already online, any kind of information that the remote servers are storing in Facebook, in WhatsApp, any kind of information of that part is your data, is your personal data according to our Digital Personal Data Protection Act. Rest physical informations that you provide, you go somewhere, you sign, or you kind of enter into an agreement which is not digitized. There might be a lot of private informations that you give offline and not online. Okay, all of that is to be taken care of by the Information Technology Act and the Constitution of India. Only our, or the ones which are digitized, are considered with the Digital Personal Data Protection Act. And this bill ensures that it will only be processed by taking lawful consent of an individual. You cannot process something without taking the consent of the other person for legitimate use of those benefits or licenses. You have to keep that data secure. You have to make sure that the data is accurate. You cannot put on data which are not accurate. It will create issues to the person due to inaccuracy of data. So the rights and duties of a data, when we're talking about right of a data principle, the purpose limitation principles, these kind of limitations of principle, the principles that we are talking about, consents, or we are talking about, eraser. So we have in India, we have right eraser. We do not have a right to be forgotten. When you claim right to eraser, that means it will be removed from Facebook. No one will be able to see it in Facebook anymore. However, right to be forgotten is different. How? Because it will not just remove from Facebook, it will remove from the remote server of Facebook also, which is not accepted in the Digital Personal Data Protection Act. Understood how it is different, Divyam?
Yes, ma'am. Yes, ma'am.
Okay. So when we are talking about rights, it is about, you correct a personal data, you erase a personal data. In case of my death, I can tell that, my younger sister should take care of it, or I have a right that my grievance is addressed. If I tell someone is using my image without my permission, someone, all these technologies have come now, deep fake technology and whatnot. So all of these, it is my right as a data principle to ensure that my data is not circulated without my permission. Similarly, when we are talking about a data fiduciary again is an intermediary. It is the body corporate which is collecting all the information, which is storing everything that you are giving. Where you are trying to talk to people online, where you're trying to share your preferences online, or you are trying to, you are creating accounts, um, just so that you can talk to doctors specific. You have applications where you talk to doctors. We have Practo, or we have MedPlus, where doctors are available online. You're trying to share something with them which is related to probably your gynec issues, which is related to your mental issues. It can be a mental health problem. You're trying to share it online, and someone goes, what they are doing is, what if they start collecting your information and run a project out of it? Okay, because a lot of people write project by collecting empirical data. Okay, that, we want to see what is the most important, or I want to see that what is the major issue of mental health, and I have 4 or 5 options. I see whether it is relationship, whether it is financial issue, whether it is unemployment. I want to see a graph of it. So what will I do? I will, first thing I do is, I approach these online applications and ask them, do you have data of people who are going through such mental issues? And can you share it with me for 20,000, 30,000, or 2 lakhs or 3 lakhs rupees? And they will share it right away, because it is a method of earning money also. So when we are talking about obligation of data fiduciary, it is very important for them to ensure that safety standards are taken care. There cannot be a ounce of data breach. The moment there is a data breach, there will be persons who are affected in India, outside India. The data might be incomplete, anything. And that is why, in such in a, and remember, in case of government entities, the data principle, the data right to eraser does not apply at all. In case of transfer of personal data outside India, the government can take a lot of steps, that, you can only share this much, because nowadays you might have seen that we have come down to artificial intelligence capturing your face. And those capturing your face, I don't know how many of you use, if you're traveling, you use DG Yatra. Before enter, you just keep on entering in the airport. You don't have to go through any biometrics anymore, because DG Yatra have saved it. But tomorrow, if the information of DG Yatra is leaked, we do not know what deepfake technology can bring to your table. because Digi Yatra has this scan of all your faces. So we don't know how far the the facial recognition devices are constitutionally protected. We do not know how the data of my facial recognition is protected. So there are a lot of intricacies when we are talking about data protection. And in those data protection, there is an exception where for prevention and investigation of offenses in our data protection act, in this digital personal data protection act, we have that for prevention and investigation of offenses or for enforcement of legal rights, claiming legal rights, it is the right, it is the right of the data principle and the obligation of data fiduciary, both will be null and void. No one will care about it. This is the exception that is given in the Digital Personal Data Protection Act. That is why the information of Riya Chakraborty was let out, as it falls under this exception. Okay, that prevention and investigation of offenses, they will ensure that the offense is the priority, because we claim to find who is guilty, we have to have enough proof, enough evidence against the person. So in India, we have a data protection board who ensures that there is this, monitoring the compliance of penalties, ensuring that all the data, all the data fiduciaries, the companies, they have proper people. That there is a proper department which will take care of their cyber security to ensure to check the vulnerabilities that are there, all of it, and this board will make sure that the penalties are given. And this is one of the highest penalties that India has ever given in case of personal data. In case of failure to take security measures, there can be as high as, the fine can go as high as 250 crores, which is one of the highest fines that we have come across in India. So, and if a if a child is involved, any kind of, like what happened with the boys' locker room case, where children are involved in kind of obscenity, vulgarity, or any kind of locker room cases, in that case, again, 200 to 250 crores will be given as penalties. So the Digital Personal Data Protection Act ensures that any kind of information, any kind of data that is shared should be protected by the data fiduciary. However, it is our responsibility as a data principal to ensure that we do not share information which we do not want others to use. I don't know how many you've seen it, but जो बोलता है ना क्राइम पेट्रोल में एंड में सावधान रहे, सतर्क रहे, it applies even to online platform, even to online platform. You have to take care of your information yourself, because once it's out there, it is it only gets worse. No matter you get a, you get all damages, you get claimed, but you fight it out. You go through a very mental ordeal to fight the whole system that this kind of personal information was shared without my permission. So why give them the scope at all? What happened with, Jennifer Aniston? She was uploading her private pictures in the Apple iCloud. But who knew that Apple iCloud can also be breached? At that point of time, privacy policy of Apple was very weak. Anyone could breach into it, and her pictures were leaked. So those nude pictures getting leaked. Now, who gets the, responsibility part of it? So for tomorrow, if Google Photos saves your gallery pictures, which you probably want to share only with the person who you are in a relationship with, but ends up getting leaked because someone has hacked into your Gmail account. So how do you manage that? The damage is already done. You're managing it comes to Constitution, Information Technology Act, Digital Personal Detection Act, all of it. But do you want to go through that process is the question. So as a right and duty your own of as being a data principal, you should not be sharing any information, or you should be taking care of the information that you're sharing. Clear, all of you? Any doubt? So I think my time is up, Sanskriti. Yes, ma'am. Okay. Yes, Agya, please ask.
Good evening, ma'am.
Good evening.
This is Arghya Patnaik, second year Kids School of Law. Ma'am, my
Okay.
question to you is, as you said, we all use social media and put some or the other private information, be it in the form of pictures, videos,
Yes.
status, etc., and it is open to our followers to have an access of all of them. So, how do we know that from
Yeah.
whom our data on social media needs to be protected, and what are the remedies if in case the information are used against us?
Okay. So see, there's no straitjacket answer to it, but I'll tell you, Arya, that because it is open to our followers, what happens is it is very easy for the people in the government, or whoever is, at least the data fiduciary, the data fiduciary, right? The company to track down from where did it go wrong. Okay, they cannot track who took the screenshot and try to morph your pictures. They cannot track it. That is why we always say that you are the one who should be careful about what kind of pictures you're sharing. But now we have come down to no one cares what kind of pictures, because deepfake technology can put you in any form. Okay, so we don't know how to handle that part of technology as of yet. But in case it is done, so we have a uh, okay, there is a law in US, the uh, the digital management copyright, okay, DMCA, the digital management copyright act, right? DMCA, the copyright act, which gives you a concept of take down notice. Okay, so, what you do as a lawyer is you draft a takedown notice and you send it to the intermediary that I want. So, suppose the picture of yours has been taken from Instagram and shared in Facebook, or has been shared in any other dating profiles, or made a meme of and shared in a website which should not be having it. You as a lawyer, or as a person, even as a data, right to the who has a right over the picture. You are a person who has the right over the picture. You ensure that you write them a mail about takedown notice. You can get a sample online which clearly says that, or you add the link where your picture has been shared or what data has been shared, which is misinformation, which leads to probably, and you write that I request you to take down this information because it hampers my privacy on these grounds. The moment you write it down, they are bound to take it down within 48 hours of your email, or 48 hours of your legal notice that you are sending them. If the information is of critical nature, in that case they will have to do it as soon as possible. That can be within 15 minutes, that can be within 1 hour, because it is hampering your image. It is huge for your image, so they will have to take it down as soon as possible. If they don't do it, then we have our IT act to take care of it. But in India, because we don't have directly DMCA, US law, we still have our, what do we say? Uh, we have two sections in copyright, okay? We have digital rights management, we have rights management information, where we ensure that our digital rights are protected. We have 65A and 65B of our Copyright Act, where we take different technologies. We use encryption technologies, as simple as using a watermark. When we are talking about a exam, the answer sheet, we have a watermark, or where we are giving mark sheet in colleges, your 10th mark sheet, 12th mark sheet, the watermarks. These are all encryption technologies that we have. So again, this is another session that I can take on. But this, by using a takedown notice as a concept, you can ask the data fiduciary to remove the content of yours which you do not want to be online. Clear, Arya?
Yes, ma'am. Thank you so much.
Okay, thank you. Any other questions? Received a message. Thanks for the session, ma'am. Nice session, ma'am. Ma'am, can you please send us the PPT? Yeah, I'll share it with Sanskriti. She can send you all the PPT, no problem. Yes. And remember to watch this. You watch Connected, you watch Social Dilemma, you watch Internet's Own Boy in YouTube. So I have one of my students here, Medha. I don't know if she's still listening to me, but she's one of my students. So one of my favorite students, and she's here. She has been in my
Yes,
circle of
ma'am.
class, and I think she knows my craze about series. So you all go back, you watch Connected, you watch Social Dilemma, you watch Internet's Own Boy, and you watch. Mm, I think these are few, series you must watch as law students, because you will know a lot about technology and how things work in your life, and it is a different. Um, but when we're talking about technology, when we're talking about virtual reality, metaverse, there's so many new concepts that are coming up. You should know about certain things which are real, and these documentaries will actually help you to know the origin of technology. Like Internet's on boy will let you know that how did technology come, how did Hain Online come. I'm sure all of you use Westlaw, Hain Online, Manupatra, this sharing database, the database that we share, all of these come from, you will know about it from this series or movies. Okay, i I hope everyone is clear with the concept of privacy.
Yes, ma'am.
Thank you again. Avnish, you have a question? No. Okay. Okay, so thank you all for joining the session.
Thank you, ma'am.
Thank you. Thank you so much, Gati, for inviting.
Thank you so much, ma'am.
Thank you. Thank you. Thank you so much. Thank you. I'll take your leave. Thank you.